I spent 31 years being the quiet one. Not shy, not weak, just quiet. There's a difference, and my brother never understood that. When our mother was first diagnosed with early-stage dementia in the fall of 2022, I was the one who drove her to the Sunnybrook appointments in Toronto. I was the one who reorganized her kitchen in Mississauga, so she wouldn't confuse her blood pressure medication with her vitamins. I learned what she liked for breakfast on bad days. Plain oatmeal, no brown sugar, tea, not coffee. Because on bad days, the sweetness bothered her. My brother Daniel lived 40 minutes away in Oakville. He came at Christmas and her birthday, sometimes Easter. I'm not saying this to make him look bad. I'm saying it because you need to understand what the next 2 years actually look like. From the inside, before the part where everything fell apart. Mom had a house in Mississauga. A real one, detached, 3 bedrooms, paid off in 2009. In the Cooksville area, which isn't glamorous, but it's solid. Our father had bought it in 1991 and worked overtime at the plant in Brampton for 17 years to keep it. When he died in 2018, it passed to Mom outright. She always said the house would go to both of us equally. She said it the way people say things they assume are obvious, not as a promise, just as a fact of the universe. Daniel called me in February of 2023, which was unusual. He didn't usually call, we usually texted, and even that was infrequent. He said he'd been doing some thinking. He said Mom's condition was only going to get worse, and someone needed to be able to make decisions for her. He said he'd been talking to a lawyer, a friend of his from his gym, actually, a guy named Trevor, and he thought it made sense for Daniel to hold power of attorney. I said I thought we should both be named. He said Trevor had recommended keeping it simple, one decision maker. Less conflict. I remember standing in my apartment in Toronto, holding my phone and feeling something cold settle in my chest. Not alarm exactly, just awareness. Like when you're walking in winter and you step somewhere that looks solid and the ice shifts just slightly under your foot. You're not falling, but you know something is wrong with the ground. I said okay. I didn't fight it. I told myself it was administrative. It was just paperwork. It didn't mean anything about the house or Mom's wishes. I told myself a lot of things that year. By the summer of 2023, Mom had moved in with me. It was the only thing that made sense. My building allowed it. Her neighborhood was getting harder for her to navigate alone, and I worked remotely so I could be there. Daniel said he thought it was a great idea. He said I was so good with her. He said it warmly, the way you compliment someone for doing something you're relieved you don't have to do. I didn't mind, genuinely. Mom and I had always been close. She taught me to bake butter tarts when I was 9, and she still remembered how to make them on good days. We'd sit in my small kitchen in the East End, and she'd talk about Newfoundland, where she grew up, and about meeting Dad at a dance in 1983, and I'd just listen. Those were the good days. They were real, and they were enough. What I minded was what I found out 14 months later. It was a Tuesday in April 2024. Mom was at her day program. She had 3 times a week by then. It helped her socialize, and it gave me time to work. I was clearing space in my spare closet to make room for some of her winter clothes I'd been storing, and I found a folder that had slipped behind a box. It was Mom's. She must have put it there herself, months ago, in one of those moments when she was trying to organize things and couldn't remember where she'd started. Inside was a copy of the original power of attorney document and a letter from a law firm in Oakville, Trevor's firm. I recognized the name, dated 8 months prior. The letter was about Mom's house. It referenced an authorization of sale listing that Daniel had signed, using the power of attorney to list Mom's Mississauga house with a real estate agent, the house that she still owned. The house she had never, in any conversation I'd witnessed, agreed to sell. I sat on the floor of my spare closet for a long time. I want to be honest about what I felt, because I think people sometimes expect a clean reaction, rage, or tears, or some cinematic moment. What I actually felt was a kind of slow, nauseating clarity, like a photograph developing in front of me. Every small thing that hadn't made sense over the past year was suddenly making sense in the worst possible way. The property tax bill that had stopped coming to Mom's address, I thought it was a Canada Post issue. Daniel had redirected her mail. I'd helped him set up mail forwarding after she moved in with me, and I'd thought nothing of it. The time I'd mentioned to Daniel that Mom sometimes talked about wanting to go back to the house for a visit, and he'd changed the subject quickly. I thought he was just being practical. The TFSA statement I'd seen once, accidentally, when Daniel had printed something at my apartment during a Christmas visit and left a page in the printer tray. A statement showing a transfer out of mom's account that I hadn't understood at the time and hadn't thought to question. I'm not a forensic accountant. I'm a project coordinator for a mid-sized logistics company. I don't know financial fraud by instinct, but I know how to follow a paper trail, and once I started, I could not stop. Over the next 3 weeks, I went through everything I could access. Mom had given me login credentials to her online banking years ago, just so I could help her check her balance when she was confused. I had never used them for anything except helping her. I used them now. What I found was this. Over approximately 14 months, Daniel had made transfers totaling just over $47,000 from mom's savings account. Some were large, some were small, some were labeled things like home expenses or medical. The house had been listed without mom's knowledge, without mine, and an offer had already been accepted. The closing date was 6 weeks away. I printed everything. I organized it by date in a binder I bought at Staples. I am a project coordinator. Organizing information is the thing I know how to do. I also called the Ontario Public Guardian and Trustee's office because I didn't know where else to start and I needed to talk to someone official. The woman I spoke to was patient and thorough. She explained that a power of attorney does not give the attorney the right to act in their own interests, rather than the donor's. It does not give the right to sell property without it being in the donor's best interest, especially when the donor has not clearly consented. She used words like breach of fiduciary duty and financial exploitation of a vulnerable adult. She told me to contact a lawyer and, depending on what I found, potentially the police. I called a lawyer the next morning. Her name was Margaret. She was a senior associate at a firm in downtown Toronto, and she had a calm, precise way of speaking that I found steadying. I told her everything. She asked for the binder. I sent it by courier that afternoon. What happened next took time. Everything in law takes time. But Margaret moved efficiently. And what she told me after reviewing the documents was that we had enough to apply for a court order to revoke Daniel's power of attorney and appoint the office of the public guardian and trustee as temporary guardian, which would freeze any pending sale of the house. She also told me that what Daniel had done almost certainly constituted fraud under the Criminal Code of Canada, and that she strongly recommended I make a report to the police. I want to tell you about the morning of the estate mediation meeting, because that's where this story turns. Margaret had arranged a formal meeting. Herself, me, Daniel, and his lawyer Trevor, to attempt to negotiate a resolution before taking things to court. The idea was to give Daniel an opportunity to return the money and relinquish the POA without a criminal proceeding if he cooperated fully. Margaret was not optimistic he would cooperate. She thought it was worth trying. The meeting was at a mediation office on Bay Street. I took the subway. I left 40 minutes early because I was anxious and I needed to walk. I got off at King Station and I was walking north on Bay when I noticed an older man sitting on a bench outside a coffee shop. He was maybe 70, well dressed in a way that was slightly threadbare, good coat, worn collar, and he had a wheeled walker beside him, the kind with a seat. He was reading something on his phone, squinting, and he looked frustrated. I don't know exactly why I stopped. I was anxious and I was going to be early anyway, and he just looked like someone who could use a second of help. I asked if he was okay. He looked up and said he was trying to find the address for a meeting on Bay and he'd written it down wrong. He showed me the address on his phone. I told him I knew the building. It was 1 block north. I recognized it. It was the same building I was going to. He said that was a coincidence. I said it was a big building, lots of meetings. We walked there together. He walked slowly and we talked. He asked what I did. I said project coordination. He said that was an underrated skill. He asked if I was nervous about my meeting, and I said a little bit, and he said that was appropriate, that it meant I understood the stakes. He had a calm way of talking that reminded me of my father, not in appearance, just in quality. That particular steadiness some older men have. When we reached the building lobby, he thanked me, and I went to sign in at reception. The receptionist told me that the other party had already arrived and was in meeting room C. She also mentioned that there was a mediator joining, a neutral third party, standard for these situations. I took the elevator up and walked into meeting room C at 9:58. Daniel was already seated. He looked good. He'd worn a suit. His hair was neat. He looked like someone who was confident about the outcome. Trevor was beside him, shuffling papers. When Daniel saw me come in, he smiled, that particular smile of his that has always meant he thinks he's already won. Then the door opened again. The older man from the bench came in, moving carefully with his walker, and sat down at the head of the table. Daniel's smile did not disappear immediately. It took a moment, maybe 3 seconds, for something to shift in his expression. I watched him look at the man, look at Trevor, look back at the man. Trevor had gone very still. The man introduced himself. His name was Gordon. He said he was a retired partner at one of the largest estate litigation firms in Ontario and had spent the last several years doing pro bono mediation work through a legal aid organization he'd helped found. He said he had reviewed the case file Margaret had submitted and he wanted to begin. He looked at Daniel and Trevor and said he'd like to start by asking whether either of them had any preliminary statements. Trevor said he did. Trevor said that his client had acted in good faith in managing his mother's affairs, that the property sale had been in her best interest, that the transfers were legitimate caregiving expenses, and that any suggestion of wrongdoing was both legally unfounded and personally hurtful to a man who loved his mother. Gordon listened to all of this without expression. Then he opened the file folder in front of him and began asking questions. Specific ones. He asked about the date of the first transfer and the corresponding documentation of caregiving expenses. He asked whether Daniel had kept receipts as required under Ontario's Substitute Decisions Act. He asked about the authorization process for the real estate listing and whether Margaret had received a copy of the signed disclosure to the property owner, which, he noted, was required when the property owner is a person under a POA arrangement. He asked Trevor whether he'd reviewed the conflict of interest provisions that applied when the same lawyer who had drafted the POA was now acting for the POA holder in a dispute about that POA's use. Trevor answered fewer and fewer questions. Then he said he needed a moment to confer with his client. Daniel had stopped looking confident. He was sitting slightly forward, forearms on the table, and his face had the expression of someone who is recalculating very quickly. I kept my hands still in my lap. I had promised myself I would not say anything that wasn't asked of me. Margaret had been very clear. Let the process work. Don't give him anything to react to. Don't make it emotional. I had agreed. I knew she was right. What I had not anticipated was how hard it would be to sit 3 feet from my brother who had spent 14 months quietly stealing from our mother while I bathed her and scheduled her appointments and learned how she liked her oatmeal on bad days and say nothing. I said nothing. After the conference with Trevor, Daniel made an offer. He said he would return $31,000, not the full amount, and step down from the POA if we agreed not to pursue criminal charges. Margaret declined on my behalf without consulting me, which we had also agreed on. She said our position was full restitution of all transferred funds, immediate revocation of the POA, withdrawal of the real estate listing, and a signed statutory declaration that he would have no further involvement in our mother's financial affairs. Trevor said that wasn't realistic. Gordon said it seemed reasonable to him given the documentation. He said he'd seen cases like this proceed to the Crown, and the outcomes for the respondent were rarely preferable to negotiated settlement. Trevor asked for a 15-minute recess. During those 15 minutes, I went to the hallway and stood by the window that looked out over Bay Street, and I called my Mother's Day program to check on her. The woman who answered said she was having a good morning, that she'd eaten her lunch and was doing a word find puzzle. I said thank you. I stood there for a moment after I hung up, watching the street below. The yellow of the taxis, the people moving, the ordinary Tuesday morning wait of the city. When we went back in, Trevor said Daniel would agree to full terms with one modification. He wanted a payment plan for the restitution rather than a lump sum. Margaret said the first payment would need to be 60% within 30 days and the remainder within 90. She would put that in writing. Daniel signed. I want to tell you what happened after, because the mediation was not the end. 2 weeks later, Margaret informed me that Trevor's Law Society had launched a conduct review based on the conflict of interest Gordon had flagged during the mediation. I don't know what came of that. It wasn't my file. The house did not sell. The court order Margaret had obtained froze the listing, and after Daniel's POA was revoked, the property remained in my mother's name. She doesn't have the capacity to live there alone anymore. We both know that. But the plan now is to sell it properly, to a court-supervised process, and use the funds to pay for her long-term care when the time comes. That's what she would have wanted. That's actually what the money is for. Daniel made his first payment in May. He did not call me. He did not send a message. The e-transfer just appeared in the designated account Margaret had set up with no note. I was at my Mother's Day program pickup when I got the notification. I read it, put my phone in my pocket, and then Mom came out through the doors in her winter coat. It was a good day. She was smiling. She recognized me immediately, and she said, "There you are," like I was the thing she'd been waiting for. And I thought, yes, there I am. I think about the quiet ones a lot now. The ones who show up and don't say much, who fold laundry and attend appointments and learn how someone takes their tea. The world doesn't tend to notice them until it has to, until they've already done everything that needed doing. And sometimes, when the moment finally comes, when you're sitting in a room on Bay Street with a binder full of evidence and an old man at the head of the table who asks exactly the right questions, the quiet ones don't need to say much then either. They already did the work. I've thought a lot about the word quiet since all of this happened. People use it like it means passive. Like the quiet person in the room is the one who doesn't have anything to say, or worse, the one who doesn't notice what's going on. Daniel always thought that about me. I could tell by the way he'd talk over me at family dinners or summarize what I just said as if he'd said it better. He thought quiet meant I wasn't paying attention. He was wrong about that. Quiet meant I was watching. I didn't set out to build a case against my brother. I set out to understand what I was looking at when I found that folder behind the box in my spare closet. The case built itself, one document at a time, because Daniel had been careless in the way people are careless when they're certain no one is watching. That's the thing about acting in the dark. You stop double-checking your work. You stop covering your tracks. You assume the silence around you means safety. It doesn't. Sometimes it just means the person who noticed is still deciding what to do about it. What I keep coming back to is this. I could have confronted Daniel directly the night I found the folder. I wanted to. There's a version of this story where I called him immediately, said what I knew, screamed everything I've been holding for 2 years of folded laundry and pharmacy runs and oatmeal on bad days. That version felt satisfying to imagine. It would have also given him time to move money, destroy records, and call Trevor before I'd spoken to a single lawyer. Patience isn't something I was born with. It's something I learned in increments, mostly from watching my mother navigate a mind that was slowly narrowing. She couldn't rush the good days into arriving. She just had to be present for them when they came. I think some of that transferred to me without my realizing it. There's a version of wisdom that looks like knowing a lot of things. And then there's the version that looks like knowing when to wait. Those are different skills, and the second one is harder, and most people never figure out that they need both. As for Daniel, I don't spend much time thinking about what he deserves, or whether the payment plan he signed feels like justice. What I think about is my mother coming through those day program doors in her winter coat on a good day, already smiling before she spotted me. I think about what her house means, not as property, not as dollars, but as the place my father spent 17 years paying for so that she would always have somewhere solid to land. That money was for her care. That was always what it was for. Daniel made a choice, and that choice had a cost. Not because the universe was keeping score, but because choices leave records, and records can be found by someone patient enough to look. I think about Gordon sometimes too, the retired lawyer on the bench outside the coffee shop who asked the exact right questions in that meeting room on Bay Street. He didn't know my story when we started walking. He just asked if I was nervous and told me that was appropriate. He said it meant I understood the stakes. He was right. I did.